As many of you are aware, there was allegations made in the Pinewood-Crawford area that there was rampant anti-Semitism in the school district. In particular, there was a civil lawsuit filed and an amended complaint filed in January of 2013 that indicated numerous instances of misconduct that were alleged by plaintiffs in a civil case that have suffered anti-Semitic discrimination, harassment, and bullying by other students for years. Indeed, in reading the allegations, the misconduct paints a very disturbing picture. The District Attorney's Office was forwarded the State Police Department's investigation regarding this earlier this year, and in our opinion, they conducted a comprehensive investigation regarding this case. Their final conclusion was that the investigation determined that none of the allegations made in the amended complaint filed in the Southern District reported incidents of prosecutable criminal conduct under the New York State penal law. The purpose of the District Attorney's Office review of the State Police investigation was to provide a double check to make sure that the investigation was thorough and accurate and to determine whether or not there were any prosecutable crimes. In particular, my office wanted to see if there was any viable criminal case that was disclosed or came forward as a result of the plaintiff's original amended complaint. Based on that review, and mindful of the strict requirements for criminal liability under the New York State penal law, I agree as the District Attorney of Orange County with the New York State Police that there are no viable criminal prosecutions. As I stated before, the alleged misconduct in the civil case paints a very disturbing picture. However, that picture is painted within the context of a civil lawsuit that has its own motivations, that operates under its own civil rules and civil burdens of proof. By contrast, a criminal prosecution has different rules that must satisfy the highest burden of proof, proof beyond a reasonable doubt. Furthermore, in our society, not every misdeed may be criminally prosecuted, regardless of how disturbing or how harassing the alleged behavior is. The criminal law's strict prohibitions govern not only how the law must be broken, but when it must be broken. Once those limitations are time satisfied, the criminal law still requires that the specific acts be done by specifically identified individuals with specific intentions or mental states. Again, all of these requirements must be proven beyond a reasonable doubt. Most of the plaintiff's allegations concern acts performed by students in middle school. However, some of the allegations relate to events in elementary school. The grades for elementary school are kindergarten through 5th grade generally. Therefore, the ages of elementary school students are between the ages of 5 and 11, generally speaking. The grades for middle school are 6th, 7th, and 8th. Therefore, the ages of middle school students involved are between the ages of approximately 11 and 14, generally speaking. Some of the plaintiff's allegations concern acts performed by students in the high school who may be under 16 years of age. The criminal law defense of infancy prohibits the viable criminal prosecution of defendants under the age of 16 except in limited circumstances. And those defendants that fit within the limited circumstances are called juvenile offenders. Pursuant to the penal law, section 30, a person less than 16 years of age is not criminally responsible for conduct except for certain crimes committed at certain ages. Moreover, a person less than 13 years of age is not criminally responsible for any act, including murder. In this case, none of the factual allegations by the plaintiffs rose to the level provided in any basis that could be prosecuted under the penal law in a criminal court by my office and the power delegated to my office under the county law. Beyond the defense of infancy, which many of the children would have had in this case, criminal law statutes reflect a policy that acknowledges the unfairness of stigmatizing some young offenders with a criminal conviction. Once again, this is called youthful offender in treatment in the state of New York. many of the alleged offenders would have fallen under that category, even if crimes would have been considered committed by them. In essence, I repeat, the District Attorney's Office's exhaustive review of the New York State Police investigation revealed no prosecutable crimes that could be prosecuted under penal law by my office. I want to reiterate that statement one more time. No prosecutable crimes that could be prosecuted under the penal law. Whether the school district complied with all of the mandates of the educational law and whether ever other civil statutes were broken must be left to the state administrative and regulatory agencies. The plaintiff's claims in their lawsuit must be left to the court that has jurisdiction over those claims and a jury or a judge trial that will ultimately decide whether or not civilly the school district is liable. That is the statement of the district attorney. At this time, I'm going to turn it over to Captain Pierce Gallagher of the New York State Police to talk a little bit about the investigation that his agency forwarded to the district attorney's office for review. Captain.
Thank you, Mr. Hoover. I'll be quick here. The State Police started this case in November 2013 over a 4 to 5 month period. We did over 130 interviews. We had up to 11 investigators a day working on this case, some with specific bias crimes training, and we logged almost 2,500 man hours looking into all these allegations. We're satisfied at the end of that we left no stone unturned, and we're confident that everything that we were able to look at, we did look at.